Good morning. We're on the home stretch, y'all. Representative Glanton.
Well, good morning, Mr. Chairman and members of the committee. Now, I will tell you that my resolution is not on the consideration calendar this morning, but I would hope that you would give consideration to the fact that I came here in advance. Amen. Amen. Okay. And so, Mr. Chairman, members of the committee, I present to you this morning the substitute to House Resolution 228, which is LC 345572S. And Mr. Chairman, this resolution is urging Congress, based on the Adoptee Citizenship Act that was introduced in the 114th and 115th U.S. Congresses, which was actually 2015 and 2018. The 2018 bill was co-sponsored by Senator Roy Blunt, a Republican from Missouri, and Representative Adam Smith, a Democrat from Washington, as a bipartisan bill. The bill seeks to amend the Immigration and Nationality Act to grant automatic citizenship to all qualifying children adopted by a U.S. citizen parent. The bill stipulates that an individual born outside the U.S. who was adopted by a U.S. citizen parent shall automatically become a U.S. citizen when the following conditions apply. The individual was adopted by a U.S. citizen before the individual reached age 18. The individual was physically present in the United States in the citizen parent's legal custody pursuant to the lawful admission before the individual reached 18 years of age, and the individual never acquired U.S. citizenship before the enactment of the Child Adoption Act of 2000 by U.S. Congress. So, in summary, Mr. Chairman, members of the committee, what this resolution actually encourages and urges Congress to do is to let that bill out of committee. As I said, it was introduced in the 114th, 115th. It's been introduced in the 116th, and we hope that they will let it out. This only involves children or folks that were adopted as children by legal U.S. citizens prior to them reaching the age of 18, which would be consistent with the Act of 2000 that took those that were 17 and below. Thank you, Mr. Chairman, and if there are any questions, I'll be happy to answer.
You have no questions.
Thank you, Mr. Chairman, members of the committee.
Chairman Corbett.
Thank you, Mr. Chairman, members of the committee. First page, second one down, House Resolution 52. All this is a resolution just encouraging all schools to recognize dyslexia as a problem and needs to be addressed. And that's what the resolution does, and if I yield for any questions.
You have no questions.
Thank you.
My senator.
Thank
Welcome.
you, Mr. Chairman. Good morning, committee. This bill that I come to request or make a request for is SB 68, LC 337507. The purpose of this bill, first of all, let me preface the statement by saying over the past years, we've had school districts throughout the state, not just in Southwest Georgia, but statewide, that have systematically turned in or passed in bad school audits. The audit department for the state of Georgia has asked them to correct those audits. Some do a better job than others, and some just can't get it right. So after looking at many, well, not many, we don't have a lot of, but they are continuous. The ones that are bad auditors or send in bad reports, they're really bad. So we're introducing a bill along with the audit department from the state and the Department of Education, that will strengthen provisions relating to financial management of local school systems and charter systems as well. It provides for monitoring by the Office of Student Achievement of high-risk or moderately risk local school systems, and it revises requirements for local school superintendents, board members, and other elected officials. So that's the gist of, or in summary, of what the, this bill purports to do. Are there questions?
Representative Williams.
Thank you, Mr. Chairman. Let me ask you a question very gently, since I heard the chairman say you were his senator. Are there any consequences? What happens? What puts teeth in this? If things don't improve, what can you do?
I'm just so certain that it will be. I'll just come back next year.
No. I don't mean.
If my
for the
bill
bu-
is
if
not,
your bi- No, I mean once it's passed.
nothing.
Nothing.
There's nothing in place to address those chronically, those schools that are chronically submitting these bad school audits. That's why I brought the bill. There's nothing really in place. What happens is the audit department will send them back to the schools and ask them to correct them. Well, 4 or 5 times, and and a lot of this has to do with the fact that some districts just don't have the manpower, as they say, to do a good audit. So after a study committee on last summer, we've put things in place where systems will help each other to get it done if they can't afford an auditor. But there are several things that we've put in place or in motion. The Department of Audit will help, GOSA will help, the Department of Education will help. So there's more assistance being given to these school districts. Does that answer your question?
Most eloquently,
Is there anything else you would like to ask?
Well, I'll ask you offline, Madam.
Thank you.
Excuse me, my senator.
Chairman Knight.
Thank you, Mr. Chairman. To the lady, 2 questions.
Yes, sir.
The first question, it pertains to the answer that you just gave in terms of these school systems don't have enough help to do an audit, but the audit that I'm looking at in this bill is a financial audit, which is done by third-party, certified public accountant that is signing off. So I'm having a little bit of a problem. How would another school system help a school system when in essence it's an audit by a third party, a CPA who is going to.
They would share the expense for the auditor or the CPA person. That, I guess that was a little confusing the way I said it. But if they can't afford a CPA firm or a financial person that's going to look at their books, say for example, I have Clay and Quitman counties in the same location of the same area. They would share that person. Half would pay, and that other half would pay to make sure that, because a lot of them said they can't afford it. And it's not that they weren't doing the audits, it's just that the audits weren't correct. Does that answer your question? They would share the expense of an auditor.
Okay, and I hear what the lady is saying, but if you've got 2 separate school systems, which are each levying, taxes through, the millage rate, how can one then make or justify the expense into another school system? In other words, all I can relate to is perhaps, my county. If Lamar County were in this situation and Spalding County came in and said, we'll share some expenses with you, then are we crossing up the expenses from taxpayers? And it's not that I don't agree with the lady. If we've got issues where the schools are not financially, are not acting financially responsibly in a way, and the audits are showing them, then I think that is a problem. But I don't know if your problem is you're saying you're getting bad audits, or the schools are not performing and thus are getting bad audits.
Well, we also looked at the fact that there's not a lot of standardization when it comes to how audits are reported to the state. So templates are being done for the districts. There's more training that's being done. So there's usually a person, which is the superintendent in the district, especially if it's a small district, that takes care of the day-to-day operations, the financial operations. And all they have to do is have the CPA or the person to come in and check it to make sure it is done properly. But that was not quite the way it was taking place.
Thank you.
You have no other questions?
That's it?
Yes, ma'am.
Thank you.
Chairman Reeves.
Thank you, Mr. Chairman. I am here to ask for, Senator Strickland couldn't be here this morning. I'm carrying Senate Bill 158, which is halfway down on the back page. It's the Anti-Human Trafficking Response Bill. It is a very similar bill to what the House has already passed in Chairman F. Stration's House Bill 324, I believe.
You have no questions.
Okay, thank you.
Senator Jones.
Thank you, Mr. Chairman. I have Bill SB 9 and also 29. I'll defer to the chair if you want to hear both. But SB 9 is on page 1. It is invasion of privacy, sexual extortion. And on section 1, which is on page 1, section 1 has actually been added by the House Judiciary Committee, but I can kind of give you an idea about what this is about. If you look on, we're actually trying to do two things here. If you look on page 2, you'll see that this is an amendment, line 49, where it says, a person who has supervisory or disciplinary authority over another individual commits this sexual assault when that person is a student, or let's say they're in a psychotherapy, or let's say they're under the supervision. What we've done here is actually amended that to where they not necessarily have to be under supervisory authority, but if they're an employee or agent of a school or of a hospital, because that person has the same kind of practical supervisory authority over a potential victim. So instead of actually stating that they have to be a supervisor, what we're saying is if they're an agent of a hospital or agent of a school and they commit a sexual act or commit sexually explicit conduct, that still would be actionable. And the second thing we've done is actually on page 1, we say with or without compensation. If you look at page 1, line 23, it says agent means an individual authorized to act on behalf of another with or without compensation. And that is important because, let me give you an example of a community school coach, for instance. He or she is not necessarily hired directly by the school system, but it is a coach which still has the same kind of power and control over a young girl, for instance. Even though they may not be hired by a school system, they may be working without compensation, they are an agent of the school system is what we're saying. And that conduct should still be actionable. For instance, you may have a person who comes in who's been hired as a nurse. They're not hired necessarily by the hospital, but they're acting on behalf of the hospital. And so that's why we say with or without compensation. What we're looking at now is to look at the agency conduct instead of saying that you have to be explicitly a supervisor of a hospital or school. We're expanding that to deal with the realities of the day, that many times we have persons that are going into this type of facilities that are not directly hired by a school, not directly hired by a hospital, but their power and control over the victim is exactly the same. So that is section 1. Our second section, section 2, deals with what's called sexual extortion, and that is found on page 5. Sexual extortion, we have in the law currently under what's called revenge porn. We have a situation where if a person receives sexually explicit material from another individual and they post that information, that is actionable. We call that revenge porn. But what happens if they demand or use threats and gain that material? That is a hole in the law. That is not actionable. So if a person receives sexually explicit material and they post it, completely actionable, that's revenge porn. But if they use threats and say, I will threaten to make you lose your job, or I will threaten to cause you economic harm if you don't send me sexually explicit photos, that is not covered in our current law. So Section 2 actually covers that particular conduct. And it is a hole in the law that many states are now fixing. Georgia would be one of 6 to actually fix that, Mr. Chairman. So that is SB 9. I'll really yield to any questions.
Chairman Setzler.
Thank you, Mr. Chairman. To the Senator, thank you for SB 9. Isn't it true that your proposition had 3 hearings in judiciary non-civil to kind of perfect it and get it to where it is today?
That is absolutely true. We had 3 hearings in judicial non-civil to try to perfect both aspects of this legislation.
Isn't it true that the version that that's been added by the House is a proposition that that Representative Chandler carried for 3 years and has been perfected in this bill, and this bill is going to get something done that we've been working on as a House for a couple years now?
Absolutely. It covers 2 areas of holes that have been in our law that persons are getting through with.
Thank you for the bill.
Representative Hughley.
Thank you, Mr. Chairman. To Senator Jones.
Yes.
When you say hospital in this bill, does that extend to other type of medical facilities as well?
And I'll go to the page, and you'll see, if you look on page 2, actually, and I was kind of being probably a little bit short than I should, we'll see that we also have sensitive care facilities, and also you'll have psychotherapy facilities on page 2. So it's going to include more than just the common term of hospital, and I apologize for just using kind of a colloquial term there.
Mr. Whip.
Thank you, Mr. Chairman. Senator Jones, my questions are around Section 8. What facilities are anticipated there in Section 8?
I think that already is in the law. I believe that those facilities would be those things that you would have a licensing facility. Just off the top of my head, you can license somebody, let's say, to do cosmetology, for instance. That would be that could be possibly a licensed facility. Once again, you're going towards that control over someone needing you to do something, and you have that kind of control over that particular person. So I think that would be just one example of a licensing type organization that you would be looking at.
And my question about Section 8 stems to the fact that in Section 9, it has a different effective date than the entire rest of the bill, and I'm just wanting to understand why.
Go ahead. We maybe, if I could.
And if Chairman Setzler can give me that explanation.
Yes, I think he may be able to give a little bit better explanation on the different dates than I will.
Thank you, Senator.
Thank you, Mr. Chairman. Title 49 deals with, as you look at these facilities, we're talking about nursing homes, hospices, those kinds of things. It's not it really doesn't deal with a nail clinic or anything like that. It's a place where people are actually getting care. The effective dates on these, and again, as the gentleman referred to, Section 8 is updating a definition because we're making changes that cascade across a number of codes. Those are really definitional updates. The effective date change is, I'm trying to go back, this dates back to last year when we made these changes because this is carried forward in our bill. Certain facilities run on a federal fiscal year and certain run on state fiscal years. And with respect to certain duties, we tied October 1, which is the federal fiscal year, and some on July 1st, which is the state fiscal year. It's no more complex than that. It deals with, as they take on duties, certain kinds of facilities have typically have an October 1 effective date. And I can do some more research if you like, if that's the short and simple.
Thank you. We can talk offline.
Chairman Ballinger.
Thank you, Mr. Chairman. Just for clarification, on the first part of the bill, whenever we are talking about consensual acts, correct? Between the employee or
Correct.
agent?
You're right. You're not going into the area of actually
Okay.
forcible rape.
So we're talking
That's
about
correct.
consensual acts.
Right.
Is there any, if I go back and I'm helping I was the star softball player and I'm now at Kennesaw playing softball, and I go back to my school and I've taken on agency at my school. Unbeknownst to me, I'm just helping my softball team. Am I providing any kind of notification that kind of my former classmates and teammates are off limits?
If you were actually going back, and I think this is actually trying to cover that kind of situation. So even though you're giving it to where you used to work with them, there's no necessarily exception, I guess might be the word. Now, as far as notification, of course, the notification is now, hopefully that will be the law that we have. But there won't be any exception because the person still will be an agent if they're coming back for the school.
Yes.
If they're coming back for the school.
Uh-huh.
And so now they're just coming back and just kind of helping, but not an agent of the school. That would be that would not even fit this particular
But if
bill.
I put on that coach's shirt, I've
I believe
taken
you're going to be
agency.
covered. Absolutely.
Okay. And now on the second part, whenever it says, I would direct your attention to lines 153 to 154. So I'm engaged in an extramarital affair. My boyfriend, the other person engaging the affair, not my husband, has pictures of me. He says, continue the affair or I will give your husband these pictures.
That's right.
Is that now a crime?
Yes, that would be
Because in my book, that's a poor choice, not a crime.
Well, what you're doing is you're saying if we're either going to continue the affair or you send more pictures, that's what we're talking about here. It's going to be a threat that's going to subject you to hatred, contempt, or ridicule.
Mm-hmm.
And what you're saying is it's the threat that we're actually making actionable. It's the threat to say, if you do not continue this particular affair or whatnot, then I'm going to release these particular pictures on you if you don't if you don't send them to me, is what it would be. So what we're doing is we're trying to trying to stop persons from threatening people to say, you must send me this particular photos. You must send me these particular photos. And let's go kind of through it.
No, I mean, I think the question is that if you already possess those pictures, but you try to coerce me into continuing the relationship.
No, what you're talking about, right. What this does is if you're demanding more photos or something of that nature from them is what we're doing. What you're talking about actually may go to the regular extortion statute because you already have them. This situation is if you don't do X, then you need to give these pictures to me or I will reveal something. You need to give me more or I will reveal it is the question, is what we're doing. If you already have them, okay, if you already have them and you say I'll post them, that may already fit within our general extortion statute.
Okay, thank you.
Speaker Pro Tem.
Thank you, Mr. Chairman. I had a question somewhat along the lines of what Chairman Ballinger was asking. It may be that I should direct it to Chairman Setzler if he added the section pertaining to the school. I'm not sure which one to ask. But so if two classmates, one, let's say the male is 19, he's a senior. The female graduates, she's also 19. She comes back as a community coach. They're engaged, and they engage in, sexual contact. They are not married. Would they be subject to this?
Thank you, Pro Tem. Where we are in this is the people under the age of 21 who are within an age range who are not married, who work at the same school and engage in sexual contact are subject to a misdemeanor. They are, indeed. And then that tracks other parts of code. And that's precisely why we parsed the bill like we did, because I think the underlying policy here is, and this was really the underlying policy that started this whole process, was if you have a responsibility in a school, you can't touch kids. If you're a bake sale volunteer, that's not an agency. But if you have an agency, you've got a key card, you're driving the church van, you're driving the school van, you're not just wearing a jersey on the sidelines, but you actually have been designated with authority consistent with the teacher, you can't touch kids in that school. So that particular person would have to coach in another school, or would have to, in that relationship, if they're going to be a teacher. It's because the question, really, the underlying question is, can a person who's a employee of a school date kids in the school? And the policy underlying here is no.
So to follow up, they would be this, the female who is the agent of the school at age 19, she would be treated differently than if she were 21.
If she were over 21,
or 22.
she have access to more exposure. What we did in the statute is we followed the existing Romeo and Juliet statute that applies across our code in a number of contexts to make sure that people that are within 4 years of age of each other, no matter the level of sexual contact, could be intercourse, could be anything, still there's no more exposure than misdemeanor. But what this bill does say is if you're a staffer in a school, you can't touch kids in that school. Now, if they chose to go to the next high school over or to the middle school, they're in a different school, there is zero exposure. But in the same school, if you're a staffer, you can't have sexual contact with a student in that school.
And so the male who could actually be in Iraq or somewhere at the time because he's 19 and engaged the female, the female would still be subject to a misdemeanor, but would be treated differently than if she were 22.
So you're saying if there was an 18-year-old male and a 20-year-old female employee of the school?
Or he's 19. I mean, we have a lot of kids who are in school actually till 21.
19-year-old male, 19-year-old female secretary at the school, let's say, because they're not going to have a degree and be a teacher, but a 19-year-old female administrator, for example, they cannot have sexual contact because they're in the same school. If she went to the next school over, she could.
Right.
But the premise of all this is that if you're an employee of a school system, not just teachers, but if you're an employee, you can't have sexual contact with kids in the same school.
My recollection on this, we've been debating this issue since actually now Congressman Doug Collins. He was the one who initiated this years ago, and I remember the concern was, where do you draw the line? And at one point, I don't know what happened with his final bill, he tried it for a year or two, we made a distinction between an employee and someone who was contract, but this does not make that distinction. It treats them the same.
Thank you, Madam Pro Tem. What this does is it recognizes the only people that are criminalized for having sex with kids are teachers and principals. And we have paraprofessionals that are outside of that definition.
Current.
Paraprofessionals, there's a pretty prominent case in Cherokee County, paraprofessionals having sex with multiple 16, 17-year-old girls, and they're completely not criminalized. This addresses that issue.
Right.
We also, Madam Chair, have community coaches, 50-year-old married men who are
Right.
having sex with 17-year-olds on their teams as a community coach. Right. Because they're not an employee, it's completely illegal.
What I agree is you can bring up the 50-year-old, you can bring up the paraprofessional. The reason we've grappled with this, though, is there's gray, and there is some gray, at least in some people's minds. It isn't always age 50 with 16-year-olds. Sometimes it's 18-year-olds who are graduated with 19-year-olds who are still at school.
That's exactly why we wrestled with it in this way. I'd be glad to answer more questions on it. This may not be the time to do it.
If y'all continue this discussion, the whole Senate's going to be in here by the time we get through.
No more questions. Thank you, Doug.
All right, Chairman Martin, you have a question?
Yes, sir. Again, to the Senator or Chairman Sessler, and I don't want to keep coming up with the one-offs here, Senator.
Okay, I'm sorry.
But serious question. If there's a situation where a student, dropped out, 16, 17-year-old student working at a company that's, doing something for the Board of Education at a school, maybe landscaping. If that individual is dating somebody at that school, violation? They're an agent. They're working on behalf of the school system.
I think that would be covered, but I'll allow Chairman Sessler to go through it also. The key thing is agency of the school, but I'll allow Chairman Sessler to talk about it.
To the gentleman's question, if they're working as a school employee of that particular school and they've been given authority, the answer is yes. If they're a contractor that shows up to build a school, the answer is no.
What about an ongoing thing of, I'm doing maintenance at the school, I'm doing landscaping, I've contracted as a janitorial service?
If they are the committed maintenance person or janitor for that school, a janitor for a school having sex with kids, yes, they fall into the definition of agent or employee. They do.
And to follow that up is the work-study program where people are still a student at the school, but are also working as in the front office. That happens a lot in schools. What about those kids?
No, they don't have an agency authority as a employee. They're still students. The thinking in all this is schools operate in loco parentis. Parents hand their kids over to schools and they have the parental authority, and that the premise behind all this is if somebody's acting in an employee capacity in a school, they shouldn't be touching kids. We did create 2 tiers where if it's just light contact, it's just a misdemeanor, but if it's full sexually explicit contact, that it would be a felony, because specifically of the holes we've got in our law as we try to balance this.
You have no more questions.
Okay, thank you.
Thank you, Mr.
Senator Martin.
Yeah, I may have been a little presumptuous coming up here without being called. I apologize for that. Thank you, Mr. Chairman and committee. I have 2 bills on page 1 on the front. We'll go over SB 60 first. I'm going to take them in reverse order. That's 4th from the bottom under modified structured. This deals with sudden cardiac arrest in our young people. Unfortunately, we actually had an event that happened yesterday with one of our football players at Georgia Tech. So we had 2 situations in Gwinnett County over the last few years where this has happened in young athletes. And so what this does is set up training and awareness for both students, coaches, participants, and their parents. And then it also sets up a cardiac protocol, similar to the way we did this with concussions a few years ago. So if a student shows the symptoms of having heart issues, then they have to be checked out by a doctor before they're able to return to participate. And this sets up, we're doing this for middle school through high school student athletes. And if there are any questions, I would yield for those.
You have no questions.
Okay, secondly, just above SB 60 is SB 48. This is a bill that deals with dyslexia. Many thanks to my former colleague, Senator Fran Miller, former Representative Fran Miller, who had a study committee in the off session. Did a great job on this, getting it started. Worked really closely with House Education Committee on this, made a number of changes. The first thing, I think one of the most important things this does is it sets up awareness, again, professional development for our current teachers. It also sets up professional development for our pre-service teachers who are still in college to give them more awareness on spotting symptoms of dyslexia in children, but also giving them tools to be able to work with those students. It sets up I always miss this word. Sets up a certification program for those teachers as well who want to achieve that certification. Secondly, what it does is sets up a pilot program for at least 3 school districts in the state to see what it would look like when we have mandatory screening for all kindergartners, so we can make sure that we identify these students earlier, make sure they get the tools and assessments that they need at an earlier age. Just like so many other things we deal with in education, the earlier you can find a problem, you can see warning signs, the quicker these kids can turn it around. Dyslexic students do excellent work. They're super smart. They just need some extra tools to be able to break through. We've had a number of them participate in our committee hearings, and they like to say they have superpowers, and I believe it. And then finally, it maintains the mandatory testing framework that we had in the original bill, but it pushes that framework back to coincide with the end of the pilot and the report back from the superintendent. What I'll say is that the pilot is subject to appropriations, and we have funding in that in the Senate budget, and then also the mandatory screening framework that's in there If that were to come into place, it would also be subject to appropriation by the legislature, so there's not an unfunded mandate on those two issues.
Chairman Smith.
Thank you. Good morning, Senator.
morning.
Thank you for your hard work on this and for those in the House who've been working on it as well. I understand dyslexia. It's a familiar term to most citizens. There are other categories that fall under the overarching dyslexia category. For example, dysgraphia. Is that one of the areas also covered?
Thank you, Representative. There is they are mentioned in the bill. We define these in the bill. We give there aren't as many tools for assessing these. However, they are often interlaced with dyslexia. So we mention those in there. We do put may language in for those. So we give permissive language for schools to screen for those if they're able to, and to offer the tools that these students may need for assistance in that.
Thank you. Further question? Thank you. And so thank you for that. I agree with you. These children are usually extremely brilliant. They're fitting into the wrong size shoes. So I'm glad we're trying to find a shoe that fits them. Thank you.
Thank you. And Mr. Chairman, if I may really quickly, we also do initially, we took out the initial mandated universal testing, but we are going to test students who are having difficulties in their reading from grades K through 3. So if they're in an RTI intervention program, we're going to go ahead and test those students as well to see if they're there.
You have no more questions.
Thank you, Mr.
Senator
Chair.
Jones, you have another bill? Come back to the front of the line. All right, here's the condition. You have to present this one in a minute or less.
I'm going to try, Mr. Chairman. This is Senate Bill 29, Waiver of Immunity of Motor Vehicles. There are times in the law where we state that you cannot sue the state, but there are times where this General Assembly says that you can. And one of those times is where an employee, including sheriff's deputies, are involved in traffic accidents. We waive our immunity under those circumstances. In this particular statute, though, we specifically state that an employee of a local government entity cannot be sued in his or her individual capacity. But we do not delineate that a sheriff's deputy is considered to be a local government employee. And what's that? And one of the things that I do is I represent the sheriff's office in Richmond County. And what that does is it allows sheriff's deputies to consistently be sued in their individual capacity. Now, because of case law, those cases are dismissed pursuant to summary judgment. But as we know, the Supreme Court has been stating that the legislature means what it says and says what it means. We have not specifically stated that within the law that a sheriff's deputy is actually immune from personal service or lawsuit within our waiver of immunity statute. So this codifies what we've been doing in case law, and we know that the Supreme Court has recently been overturning itself where the General Assembly does not specifically state that a particular entity is involved in a law. So this codifies case law to make sure we do that. I'm sorry, Mr. Chair. I want to make sure we I'll yield to any questions.
Shorter is
Don't-
better, I promise.
Don't yield.
Whip Kelly.
Thank you, Mr. Chairman. As a fellow member of the bar with you, I'll just remind you how much us attorneys like to talk.
Yes.
And so I wanted to just make sure you've referenced Davis v. Morrison, the appellate court case from 2018. Do you know if that's been appealed up to the Supreme Court?
It doesn't seem like it's been appealed up to the Supreme Court yet, but that case is the case that says that deputies cannot be sued in individual capacity, but it doesn't seem that it's been appealed yet.
My only concern is us passing legislation that would impact a current pending case, and so that's just my only concern with this. And I understand what you're trying to do here, and I do agree with you on the principle of sheriffs and sheriff's deputies having the same protection as other law enforcement, but that's the only concern I have.
And of course, this would codify exactly the ruling that they gave us in the Court of Appeals case.
With the Court of Appeals.
Yes.
Representative Williams.
I hate to interrupt this party between two distinguished members of the bar, but will your next bill be simple?
I will try. This is my last one, so.
You have no more questions.
Thank you, Mr. Chair.
Senator Black.
Good morning. Thank you, Mr. Chairman. Got two little bills on the modified open rule, we got Senate Bill 75, which is a little vet bill. Got two provisions. Allows them to put a registered veterinary technician on the state board. It also sets up an entity that allows them to check a veterinarian that's having some, I'll say, addiction problems to get to that entity to deal with some treatment. Any questions on that?
You have no questions.
On the back page, under modified structure, we got Senate Bill 117. This is a retirement bill. And I think everybody in here realizes that we have a real serious problem with our retirements, in particular the teachers' retirement. It's the big one. And it might not bother y'all, but it bothers me that we're having to put in over 20% of the payroll as a boost to the retirement of these teachers. And we're going to have to continue doing that for the foreseeable future until somebody musters up enough political courage to make some drastic changes. And I don't see that coming. So I've been working on a number of issues that will try to whittle this down some. This bill, it won't solve the problem, but it will be a step in that right direction.
Senator, who'd you just call gutless in this room? Political courage.
Political courage.
All right. You want to
Any
ask
questions?
a question? Yeah.
Senator Black.
Yes, sir.
There's several things in here that this bill does, and one of the things it does is change after July 1st to make it more difficult for people to buy the years that they don't work here. Is that correct?
That's correct.
And that's good, is it not true? Because even at full actuarial cost, there's some obligation hung on the taxpayer. Is that not true?
I'm sorry, that last phrase, some obligations.
Even at full actuarial cost, there's still some risk put on the taxpayer if people buy into the system, because people are living longer. You can't pick interest rates. Isn't it true?
If the actuaries would do a good job, there wouldn't be. But under the current situation, the answer is yes.
Well, isn't it true that by definition, regardless of the job they do, people are living longer and they can't look into the future any more than you and I can? So they're doing the best they can, but taxpayers are still going to be obligated if people buy into the system. Is that right?
Well, I think at some point in time they will address this.
Okay. Well, it leads me to one of the last sections in the bill where you are allowing folks to buy into the system that you are concerned about and finance that over 10 years. So on the one hand, we're making it harder to buy the years. On the other hand, you're making it easier. And I just wonder, why would we want to allow them to expense this over a 10-year period?
I have some confidence that we're going to face some times when these actuaries are going to come up with some more accurate assumptions, and that will not be a liability.
Mr. Whip.
Thank you, Mr. Chairman. I just want to ask the senator, obviously we've heard a lot of concern and hear about the 10-year period. I've heard certainly a lot of concern from our members about the 10-year period. Would you still support the measure if we did not allow someone to extend this over equal payments up to 10 years?
Well, first off, it'd be better than what we got now, which right now they got to do it immediately. I'll also point out to you that in here there is an exemption for the local governments. And folks, we've got right about 500 local retirement systems. And all but about 40 of them are very well funded. I'm going to tell you, it's an embarrassment to the state that our local governments can do a good job of managing their retirement systems, but the states come up short compared to our local governments. But our local governments have asked it to be exempted from this because they feel that there are situations where it is to their advantage to give a bonus to this potential employee. This is a recruiting tool to provide an incentive to get the employees that they want.
So if we did though strike the language that gave you up to 10 years to pay this, you would still be okay with the bill?
Well, I would prefer that you stick to 10 years because I think it enhances the ability to use this as a recruitment tool. But it would be, if you reduce that 10, it'd still be better than what we have now.
All right, thank you so much.
Chairman Benton.
Thank you, Mr. Chair. For those of you that are concerned about the interest being charged on the installment payments, I have a letter from Jim Potman, who's the Executive Director of Employee Retirement System, where he states in the letter that the actuarial assumptions do include interest being charged on that. And I'll be glad to provide that letter for anybody that needs to have a copy of that.
You have no other questions? Senator Payne.
Thank you, Mr. Chairman, members of the committee. Bring you two bills this morning. Senate Bill 43, which is on the first page on the modified structure rule, and also Senate Bill 104, which is on the second page, the third one down on the second page, also under the modified structure rule. Senate Bill 43 is to bring parity for the City of Dalton. The City of Dalton, by unanimous vote, is the one that requests this bill to allow the City of Dalton and the Dalton utilities to issue revenue bonds for power transmission needs. And so this has also been we have agreement with Georgia Power and members of MEAG. We've all worked on this bill together to make sure that the language is agreement with everyone. And this would just allow the City of Dalton to have control of their own destiny as far as issuing revenue bonds for infrastructure and needs as far as power transmission.
You have no questions?
And also I have Senate Bill 104. This is really just a housekeeping bill to bring clarity to the law. Right now it's already against it's always required that a parent or guardian or legal authority give consent to a hospital or doctor for issuing a do not resuscitate order on a minor child. This bill just simply, in the current law though, it says in how a parent can give that consent, it says a parent may, and really just trying to get rid of that a parent may consent language and bring this. We've worked with Georgia Public Policy Foundation and also all others, not Georgia Hospital Association, with the current language, and we've reached a consensus, and that's Senate Bill 104.
You have no other questions?
Thank you. I just ask for your general support. Thank you.
Senator Anderson.
Mr. Chairman, I bring on the back page structured rule, Senate Bill 144, and probably be the quickest, fastest bill ever in here. It's a good bill, it's a good cigar bill, and it's a bill to make it where you can get a temporary permit instead of having to get a permanent permit to do a temporary permit. Off-site events.
Chairman Fleming.
Thank you, Mr. Chairman. Senator, this little golf tournament that we have over in Augusta every year, a lot of the patrons want to buy cigars, and a lot of our cigar dealers have trouble providing them near the course because you can't get a license to sell there without this bill change. Isn't that right?
Yes, you're so correct.
You have no other questions?
Thank you.
Senator Kennedy.
Good morning, Mr. Chairman and members of the committee. I bring to you Senate Bill 157, second page, ninth from the top. This creates a deposit placement program so that banks will be able to receive more of your local government funds and then distribute them among the other banks that are within the network. The GBA and the CBA both like this. Your local governments will like this. This will give more flexibility in where they can have to place their local funds and be FDIC insured.
You have no questions?
Thank you, Mr. Chairman.
Members? Any members? Representative Blackman.
Thank you, Mr. Chairman. Just to ask for Senate Bill 65, Senator Harper. It includes title transfer with regards to TAVT, but also includes the language as passed the House on our cleanup with title ad valorem tax. with one change, the delayed implementation at the request of DOR to January 1 of 2020.
Mr. Rogers.
Thank you, Mr. Chairman. I'd just like to put my name by SB 106, the Patients First Act, also SB 110, the statewide business courts, and SB 158, the Anti-Human Trafficking Act, please.
Chairman Powell.
Thank you, Mr. Chairman. I'd like to ask for SB 153, the Trauma Cleanup Regulatory Act, also Senate Bill 157, and put my name beside SB 117, Chairman Black's Profile and Courage Bill.
Mr. Hawkins.
Thank you, Mr. Chairman. I'd like to ask for SB 66, streamlining the Streaming Wireless Facility and Antennas Act.
Mr. Williamson.
Thank you, Mr. Chairman. I'd like to put my name beside Senate Bill 37. It clarifies how changes may be made in the terms of a contractual agreement.
Chairman Setzler.
Thank you, Mr. Chairman. I was going to ask for SB 9, but I'd like to ask members to come see me about SB 9 that have questions. There's a lot of work's been put into it. I'm glad to get in the details. So appreciate you, Mr. Chairman.
Chairman Benton.
Thank you, Mr. Chair. I'd like to put my name beside several bills. Chairman Corbett's House Resolution 52. Senate Bill 75, I'm sorry, Senate Bill 68, Senate Bill 48, dyslexia bill, and Senate Bill 117.
Chairman Green.
Thank you, Mr. Chairman. I'd like to put my name besides Senate Bill 68 and Senate Bill 157.
Mr. Bodie.
Mr. Chair, under modified open rules, I would like to put my name beside H.R. 72, Representative Darshawn Kendrick's bill, and also on a modified structure rule, I would like to put my name beside SB 29, Representative Senator Jones' bill.
Chairman Martin.
That was his life.
Okay. I understand. Community Mike. Okay, we've got no other members to request bills. Here's what we're going to do. We're going to set a calendar for today, and then probably at the lunch break, we'll come back and set a calendar for tomorrow, so we'll be back on track as far as being a day ahead. So for today, under modified open rule, H.R. 52. It's on. Modified structured rule, SB 37. It's on. Modified structured, SB 48.
Move.
It's on. Modified structure, SB 60. It's on. Modified structure, SB 66. It's on. Modified structure, SB 91. It's on. Modified structure, SB 106.
Move.
It's on. Modified structure, SB 110.
Move.
It's on. Modified structure, SB 161.
Move.
It's on. Modified structure, SB 184. It's on. Modified structure, SB 225. It's on. Structured rule, SB 144.
Move.
It's on. Structure, SB 183. and it's on. Structure, SB 216. It's on. And we are adjourned, and probably we'll see you at the lunch break. What? Oh, yeah, wait, one more thing. We have a motion here.
Mr. Chairman, pursuant to Rule 33.3, I move that we limit all debate to all bills on all calendars today to 1 hour at the discretion of the Speaker.
All right, there's objection. All in favor, say aye. Aye. Any opposed? No. Motion passes. We're adjourned.